Hey, good morning, folks. Welcome back to Law and Legitimacy. It's Tuesday, I think. Or is it Wednesday?
It's Thursday.
It's been a long week.
It's been a short week.
I don't know what day it is. I do know that today I'm heading up to the Cape with my wife for a long weekend. And
Good.
Can't wait to get going. So, lots going on in the news today. I wasn't going to announce this, but I'm going to anyhow. At 11:30 today, the appellate court will announce whether to sustain my suspension from the practice of law, given Judge Bellis's suspension of me in the Alex Jones case. Who will respond to that decision when it comes out. Obviously, I'm apprehensive and anxious, as anyone would be. Today comes the judgment, so keep an eye on the news. I'm sure it'll be reported, and I'll probably report on it from the Cape tomorrow, or maybe even this evening, if I bring my material with me. But we promised today to ponytail versus no ponytail. Jules,
what a dumb bet, what a dumb bet, Jules.
Why is it a dumb bet?
You get it. The ponytail is obviously going to be here,
I don't know. I've been thinking for about 2 years about getting a haircut. And I thought today, hey, you know what? If I get suspended from the practice of law and I've got to go out and earn a living, maybe I should cut my hair, And I mean, if I'm going to sell pencils to Shriners, I mean, they may not want a guy with a ponytail,
Well, we need to start looking for, maybe we need to take bets on the odds of which barbershop you attend for this ceremonial event in the New Haven area. So we'll do some research on that, maybe.
And don't even assume that it'd be in the New Haven area. I could just as easily wander into a shop on the Cape and get it done. One of these days I will, though, because I'm getting tired of having to brush it out every day and the various mats and whatnot that accompany it. I grew it years ago thinking it was easier than heading to the barbershop all the time, and I had issues with authority, and it became sort of a moniker.
That is surprising.
What?
That you had issues with authority.
As I still do. I know. Is it any wonder that I'm in trouble with the bar in my geriatric dotage? No. The wonder is that it took all this time for it to occur. But anyhow, Donald Trump, we promised to read the various briefs on the motion to suppress. It's your motion, Mr. Trump. Make your argument.
Woo! Let me finish getting this stuff done over on Rumble and whatnot. I'm having to change titles and put the thumbnail up. So yeah, that's correct. We did promise some independent homework, and we've done the independent homework. What's interesting, Norm, I don't know if you've looked at because I know I sent you the briefs that we downloaded.
Mm-hmm.
How many events in Pacer there are for this case in the Southern District of Florida? Can you take a wild guess how many entries there are?
672.
I mean, it's not a bad guess. It's in the upper 500s. We're in the I think the 570s now, just tracking back. And this case really isn't that old, truth be told. So there's a lot of activity. For those of you, for the uninitiated among you, Pacer is just the online federal court docket tracker. And attorneys and anyone with a Pacer account can log in and track every entry from both parties, including the judge and the judge's clerks in a given case. And in this case, there have been nearly 570 individual entries since this all initiated. Ooh, look at Jeff out here with a zinger. My wife said you need every extra inch you can get.
Here's what I want to know, Jeff. Why does your wife care how many inches I have? I don't know your wife, Jeff.
That's a good one. What kind of bagel you got there, Norm?
Cinnamon.
All right. Well, I'll stop biding time here. So what Trump filed on May 21st, so just a couple of days ago, as reported, was titled, the long title of Motion for Relief Relating to the Mar-a-Lago Raid and Unlawful Piercing of Attorney-Client Privilege. But in more layman's terms, Norm, it's a motion to suppress the evidence the FBI, pilfered, yielded during its raid of Mar-a-Lago, the notorious raid.
One might say seized.
Yeah, seizure is a good word when we're thinking about Fourth Amendment Fourth Amendment content. There's also a motion to compel what's known as a Franks hearing. And I want to make sure that we give some time, Norm, for you to talk about the nature of a Franks hearing in context here and more broadly, and ultimately for the court to dismiss the lawsuit altogether. The government has responded, and Trump's legal team has followed up a reply to that response. But principally, what I found the most interesting about this motion, Norm, to suppress is the background, the narrative that was driven to the court, principally based on the lack of good faith negotiations between attorneys for the government and for President Trump. So the foundation is laid by Trump's legal team in the brief to say that that in comparison to the Hillary Clinton camp and the classified servers issue, etc., every part of that investigation was completed by and through the good faith exchange between attorneys for the government and Hillary Clinton, meaning that that Trump's legal team is setting the stage to say that the warrant was unnecessary, and they go further to say that the DOJ and the FBI both knew that the warrant was unnecessary, and quote, I don't give a damn about the optics, right? So that's the foundation laid there. To say
it's not
that,
much of a legal foundation, though.
no, it's not. But it is context, I believe, that raises the more important issue, which is I guess the defects in the alleged warrant, right? So the overbroad and vague nature of the warrant. Number one, that the Trump's estate is 17 acres, 50 something rooms, bedrooms, and all sorts of just a massive grounds, and that the FBI's affidavit and the warrant together were disparate, and aspects of the warrant did not include other aspects of the warrant, and otherwise sort of contradicted each other. But more broadly, the issue is that the raid was done in a hostile manner. It wasn't necessary, and the warrant should not have been issued to begin with, which is what brings us to the question of the Franks hearing. So I'll stop there and let you fill in.
Yeah, so I misunderstood the homework assignment. I thought you were going to argue Trump's perspective, and I was going to argue Smith's. So I didn't review the Trump brief with detail, but I did.
Nor have I reviewed Jack Smith's brief, but we can go on.
I did review Smith's. And so let's take some of these issues one at a time. First, let's talk about the concept of a perp walk. A perp walk is when the government arrests somebody, a perpetrator, and walks them to the courtroom or from their house or through some public location amid great media fanfare, usually in handcuffs, accompanied by a couple officers in raid jackets or in uniforms or in men in blue, FBI uniforms. And the message to the public is that this person is guilty. He's been arrested, he's in seizure, and law enforcement officers are accompanying him to an official location. That's a perp walk. The first complaint the Trump team made is that a warrant was unnecessary because it became the functional equivalent of a perp walk. Whereas in other cases where claims of abuse of executive privilege or retention of executive information was raised, lawyers and for the government and the party were able to work it out under conditions of goodwill and with a lack of scandal. So that's issue number one. Second, so the question is, does this choice of how to proceed yield a legal remedy? The Fourth Amendment says simply that the government cannot engage in a search or seizure without probable cause or without a warrant in certain circumstances. It doesn't say anything about perp walks. It doesn't say anything about having to play nice with a person you suspect of a crime.
To be fair, nor does Trump's motions. They don't mention the perp walk at all.
No, I use that just as an eye-catching analogy to help people understand it. So I was, there was some hostility according to what I read between Trump's lawyers and the government's lawyers aren't obliged to say, we'd like to come in at 5. Please open the door for us and have our tea and crumpets ready. They can choose the manner, and they can choose the time to enter. They can make an evaluation about what best serves the government's interest. They can take the temperature of the other side, and if the other side has been less than cooperative, they can use the element of surprise if that's going to increase the likelihood that they seek what they want. So if
I'll stop you there. I'll stop you there. So I want to make sure that when we talk about, I guess, the foundation, and I know I said the particularity requirement wasn't met, but Trump also, his legal team also alleges as a primary matter here that the warrant was procured by fraudulent misrepresentation to the court, right? So principally what you just said is that they don't have to take a certain course of action over the other. Trump's motion actually says, and I quote, Agent Redacted failed to disclose that the FBI had taken the position in writing, apparently, that it was not necessary to execute a search warrant at Mar-a-Lago. The FBI's assessment conflicted with Agent Redacted's sworn assertion that the warrant application needed to be sealed because, quote, disclosure may have a significant and negative impact on the continuing investigation and may severely jeopardize its effectiveness. To the contrary, Agent Redacted's boss actually believed it was more appropriate to seek consent for the search from Mar-a-Lago than simply executing a search warrant or getting a search warrant and actually executing the warrant. So that's
now we've shifted topics to the so-called Franks issue. The first issue is how the government executes a warrant. A second issue before we get to Franks is the particularity requirement. One reason that the Fourth Amendment was written to say that a warrant must describe with particularity the items searched for in the area to be seized was to avoid the problem in Britain of general warrants, where the king might sign a warrant and say, find everything you can about Mike Boyer, and then the king's agents would stomp through the colonies, go without limitation. The Franks issue is a narrower issue. When a magistrate reviews a warrant, that is, when a judge reviews a warrant and decides to sign it, the judge is confined to the 4 corners of the warrant. That is, the material that is written in the affidavit under oath by officers, summarizing the reasons to believe there's probable cause for a warrant. If officers leave out of their warrant material facts that undermine probable cause, and they do so knowingly, that will give rise to a Franks motion, a Franks hearing. A similar question is if officers make up stuff that simply isn't true, know it's not true, and stick it in the warrant. So in a Franks analysis, you're looking for material omissions of exculpatory information or material inclusions of false inculpatory information. And when you do the 4 corners analysis, you either exclude or include material, and you have to persuade a reviewing judge that the inclusion or exclusion of that material would undermine the warrant. The warrant wouldn't have been signed. The internal debate that Trump refers to between agents about the necessity for the warrant or whatnot really don't go to probable cause for the warrant. They are evaluations about whether they could obtain consent to get in, or whether consent was necessary at all, or whether a warrant and the attendant process was in the national interest. These aren't probable cause determinations. These are policy considerations. And so were I Judge Cannon, and I think Smith rightly says in his response to Trump, these aren't Franks issues. They haven't even produced a colorable Franks issue. To raise a Franks issue in court, you have to do more than say, oh, it's a bad warrant. You have to produce an affidavit that demonstrates to the trial court why the warrant is bad. What facts in the warrant are included that are false, and the officers knew them to be false? What facts are included in the warrant that are true, that the officers excluded because it undermined that case? If you can put that in an affidavit, get it before a judge, and the judge then does the 4 corners analysis of the warrant and concludes it's a bad warrant, then you get a hearing on whether to suppress. Smith's office, in my view, blew Trump's claims out of the water. Trump basically said it was bad politics, bad optics, bad policy decisions, but he didn't even really address the issue of probable cause. So in my view, it's a failed effort.
Well, but it does matter that there were many cited reasons that the magistrate judge would have been misled into issuing the
Give me one.
in the first place.
Give me one.
I gave you the one already. The first one was just that the FBI had taken the position in writing that it was not necessary to execute a warrant. And then there's an issue of
that's not a reason. That's not going to give a judge pause. Some agents say that's not necessary. We can go in by consent. The government gets to choose. There's no requirement in the Fourth Amendment or in the law that I'm aware of that says if agents reach the conclusion that they can get the material by consent, they can't get a warrant. They can't pursue a warrant.
We've got three more. So the second misrepresentation to the magistrate judge would be that the redacted agent failed to disclose that presidents are not required to obtain clearances and that sensitive briefings including classified information had been provided to President Trump at Mar-a-Lago and other residences before and during his presidency. Now, you're asking, why would that matter?
The claim here, however, is not that he had a right to this material before and during his presidency, when he was being briefed to assume the role and when he performed the role. The claim is that he retained material after he lost the role. So I don't see how this is material or relevant to a Frank's analysis.
Well, it's because they actually lump all of those various classifications of classified information or not classified information together. They leave out the presidential records aspect of all of this and omit that entirely. And then they also, I believe, the brief focuses, Norm, on the fact that the FBI knowingly gave secure and classified information and held briefings at Mar-a-Lago with Trump, never actually gave him a security clearance for all of that, but then sought to, after the presidency was over, treat Mar-a-Lago as not having a security clearance as a major basis for applying for the warrant to begin.
Well, it didn't have a security clearance.
Right, but if there were presidential briefings held there in concert with the FBI and that was known, and they omitted to reference any of that in the warrant, but used the fact that it wasn't a cleared place, even though they were looking to search the presidential office that he has in Mar-a-Lago, that's a big deal, right?
I don't know. He was no longer president. He lost the status. He lost the status.
He doesn't have security clearance, even though they've been transacting presidential business in concert with President Trump at Mar-a-Lago for the entirety of his presidential term. That's a big deal to me.
Less so to me. And, Blue Raptor Bird is accusing me yet again of Trump derangement syndrome.
Do some chin-ups, Blue Raptor, bro. You're weak.
Blue Raptor, go get your hair dyed orange. Go to a tanning parlor. Say some D's and Dems and buy a MAGA hat and then go stand on the street corner and sell pencils.
Just do some chin-ups. That'll help.
Yeah.
Third, Agent Redacted suggested that the FBI had only initiated its investigation after the referral from the National Archives on February 9th. This misrepresentation is consistent with the superseding indictment, which alleges that the FBI, quote, opened a criminal investigation on March 30th of 2022.
Okay, so the law talks about materiality, facts that matter. Why does this fact matter?
Why wouldn't it matter?
No. Why does this? You're the moving party here. You're arguing on behalf of an extreme remedy. I'm asking you why this fact matters.
Well, because the exhibits that were provided as part of the motion show that the National Archives General Counsel was interacting with Trump's legal counsel, asking to get some specific documents back about North Korea in particular, right? And that email chain, which I read, spanned a couple of months. The issue is that the general counsel for the National Archives at a certain point decided that he was, I guess, dissatisfied with the speed, even though it was just a couple of months, it was during the summer, the speed with which, getting some of these boxes back was taking place. And President Trump's legal counsel at that point told him, hey, we'll get this stuff FedEx. There was an issue of how to get this stuff back to him. Hey, do we need to have it hand delivered? If so, we need to get a driver. Are you okay with FedEx, even though they're original documents? Need to confirm all of these details. If so, we can have somebody come down to you. That question never got answered. Then the next email that you see in the thread is the National Archive General Counsel saying that he was going to refer the matter somewhere else. So if the FBI is telling a magistrate judge and applying for a warrant to raid and seize, information related to whatever, there was no urgency placed in any of the conversations with the National Archives. There wasn't even a supposition that what they were asking for, they were legally allowed to have, right? What they were asking for was, I guess, in conformity with existing precedent, et cetera. But setting that aside, if the FBI said that the referral came from the National Archives, NARA, and that they opened the investigation in February, but then contradict themselves and they discard that and say that they opened their own investigation over a month, like almost 2 months later. So early February versus late March, that's material to me, because what's the source of this investigation, as it were?
I don't know. The question to me is, was there probable cause to believe that items that Trump was not allowed to have were present at Mar-a-Lago on the date the warrant was signed? And so the fact that there may be inconsistencies in when the investigation opened doesn't seem to address that question.
Well, but again, I think that you're taking, obviously, I know you're taking the position of Jack Smith for the exercise, and you're playing that role here. It's just a little ridiculous to me that we would be talking about the FBI deciding within months of the end of his presidency to apply for a warrant to raid the property and seize documents, right? When the existing context for these issues was hammered out between attorneys with consent for years on end up until this point. This is the only unprecedented fact within the application of a warrant to seize documents from a former president's private property is this one, the departure from precedent that is represented by former President Trump.
And
right?
isn't the claim that part of the precedent was the fact that counsel and for the former president and the government couldn't reach an agreement? And
that was not true. That's not true at all. That's not true at all. What I'm telling you is that there were ongoing communications between NARA and President
there were
Trump.
ongoing communications, but they hadn't resulted in the complete exchange of information. How long does the government have to wait?
The complete exchange
requirement.
When were they going to tell how they wanted the documents to be provided back? They offered to send somebody. If they were in DC, they would have sent somebody by personally to grab them. But because they were in Florida, they needed to come up with some sort of other logistics operation. Trump's team asked, hey, how do you want it done? Are you okay with FedEx of original documents, especially as it relates to North Korea, right? But we can move past this issue of materiality. There's two other issues there, but I think just in the interest of time, the particularity requirement norm, right? So is a warrant issued for a 17-acre property spanning 50, almost 60 bedrooms and whatever else you can imagine in the search for information, because there's also a credible allegation here of the attorney-client privilege being completely quashed in the effort here, that they actually took like accounting records and all sorts of bank information and personal medical records and stuff like that as part of their search.
So the particularity requirement obviously is intended to avoid the general warrant issue. And so a 17-acre compound with 50 rooms does present a problem. I don't know if the FBI should have said, we want to search only bedrooms, we want to search only conference rooms. I think if I'm the agent tendering the affidavit, I'd want to do the entire complex, because that's a complex that the president or the former president he and his staff had access to as a private dwelling with contiguous walls attached to one another. But it is an issue. I don't know if the judge will struggle over it longer. They will. I
mean, because there were like 47 pictures taken of Melania Trump's bedroom and another 20-something taken from his son's bedroom, even though
that's embarrassing. That's embarrassing.
Zero assets they seized nothing from those bedrooms whatsoever, right?
And that makes the FBI look like a bunch of lurid tourists.
Correct. And that's why I mentioned the departure of precedent on the front end to say, where were the especially in consideration for what Secretary of State Hillary Clinton was tied to with respect to foreign policy, certain really embarrassing occurrences abroad to do with U.S. embassies, etc. Acid washing servers. At what point was the FBI going to apply for a warrant to search her properties for certain classified information?
It should have.
Okay, but it did not. So what about Trump's position when he has his team working in concert with the National Archives, because that's the only people at this point that have reached out, right, over something specific, a la the North Korea information, etc., right? And then there were questions about other stuff. And Norm, those exhibits actually detail where there was, hey, we need to actually circle up on our end to figure out, exactly what these things are, etc. But there isn't, we don't just treat everything purported to be classified as classified. We're talking about a former president, right?
So the fact that they should have gotten a warrant as to Clinton doesn't undermine the fact that they did as to Trump. That could raise a selective enforcement claim, which is not what's before the court right now. Selective enforcement, selective prosecution, those are very difficult claims to raise, but that would be a better issue than the Franks issue here. As to attorney-client information that was received, that raises a very serious issue.
Yeah, that was they spilled a lot of ink on that. I know we've talked a lot more about the Fourth Amendment issue here, but they spilled a ton of ink, probably half of the initial motion to suppress, discussing the crime fraud exception as not being applicable, right? But attorney-client privilege, assertion of the privilege, the exceptions thereto, the crime fraud exception, etc.
So any communication between a client and his lawyer, wherein the client is seeking the lawyer's opinion or advice about a course of legal activities, that's privileged. And it's privileged for a number of reasons. One, and by privileged, it means that no one else can obtain and lawfully use that material unless that material meets certain circumstances. So, for example, I write to you as my lawyer and say, Mike, I need a bank loan and I need it immediately. What steps should I take to get it? You might say, gather all your income tax returns, make an appointment with a loan officer, give them a profit and loss statement for your firm and, your checking account. And that would be legal advice, and nobody would be entitled to know that. If you also said, gin up your numbers on income, basically pretend that you made more money than you did, that might be an indication of fraud. You might be advising me to engage in fraud. And the crime fraud exception to the attorney-client privilege makes does not or penetrates the privilege. A lawyer cannot advise a client to disregard or break the law, and neither the client nor the lawyer can then use the attorney-client privilege to prevent the government or some other agency from discovering the fraud. The question is, how do you discover that? And so, if you seize if you seize communications between a lawyer and a client, that raises questions right from the get-go. What was the authority to raise them? Then you'd have to say to a reviewing court, we had some reason to believe, probable cause to believe that there was fraudulent activity at that point. At this point, a taint team, T-A-I-N-T team, would be appointed, a team separate from the prosecutors handling the case, but part of the Justice Department nonetheless. And that team would review the communications to see whether there were any that satisfied the crime fraud exception. This is an important issue, it would seem to me, in this case, and it's something that should cause Judge Cannon some issues. But on balance, this case is not going to be dismissed on application of this. Mr. Trump did not make out sufficient grounds for a Franks hearing. I think Smith conclusively demonstrated that. The warrant described with particularity the place, the manner in which it was executed, the seizure of photographs of private bedrooms and whatnot is embarrassing. That material will likely be suppressed. But I don't, again, think that this is going to amount to grounds to dismiss the action. The crime fraud issues, I don't know enough about the context. I'd have to see the communications. And the likely remedy there would not be dismissal of the indictment, but preclusion or prohibition of use of those items in the government's prosecution on its case in chief.
Well, so, and Norm, just, not, sorry to cut you off, but this does not exist in isolation. The context for this, recall that this trial or this proceeding had been halted indefinitely, right?
Mhm.
And that was based on the disclosures that Jack Smith's team had made that contradicted quite a few earlier disclosures in the case. And the issue that Cannon had now is with the credibility of Jack Smith and his legal team and the documents in the case being put before Judge Cannon.
Well, let's see what
This
happens.
to me represents, I mean, that's relevant and I think perhaps changes a little bit of your, I think, steadfastness to the conclusion that this won't be dismissed. I actually think it's quite likely that we get at least a partial dismissal of this case. But because again, what are the 34 counts in total as part of this case and several other defendants? I do appreciate that and severe conservative acknowledges this love norm pushing back versus Trumpers. It's his contrarian nature. I think that's, obvious to me that you are likely to take that side. But I do think just on balance, Jack Smith is still has a massive uphill climb, and I think the willingness to file these motions at this stage of the case is really important, especially considering what's come out and the optics. I think that Trump's legal team would be remiss not to, right? It would be a
Well,
huge
we'll
missed
see.
opportunity.
I disagree with you. I don't think any part of it's going to be dismissed, and it has nothing to do with my being a contrarian. It has everything to do with me being a criminal defense lawyer and having spent decades evaluating search warrants and trying to get portions of them undone. The Frank standard is a difficult standard, and the materiality standard, that it's not every fact that would support an application of Frank's. It has to be a fact which, if true, undermines the conclusion that there was a justification for the warrant. And so a mistake that litigators often make is they focus on immaterial facts to reach the conclusion that a warrant should be
Get back over the mic. Get back over the mic.
the immaterial facts to reach the conclusion that a warrant should be vacated. And I just don't see it here. So, there you go.
Well, and I know that we do see it differently. I think I do think the representation to the court that the investigation started at one time and then started at another time through different sources is very material. And I do think that the FBI having said in writing that a warrant and a search was unnecessary is also material. Again, I'm not taking anything away from the magistrate judge that issued the warrant. I think that the execution of the search warrant, it speaks for itself in terms of egg on the face, how overly broad it was. Even if you think that there's, a legal argument to say that it's, legally enforceable and valid within the context of an estate the size of Mar-a-Lago with seeming no limitations at all. But I do think that, the fact that they made such clear omissions and misrepresentations regarding dates and sources of the beginning of the investigation, to me, would meet the Frank standard, especially in the case of Trump. I mean, this isn't something, and I know that, your criminal defense work is, far and beyond my experience as an attorney. But it occurs to me, Norm, that Jack Smith is on his heels here. It's not as, it's not as cut and dry as might be seen on Garden Variety.
Blue Raptor Bro. And Blue Raptor Bro, I'm going to recommend a new podcast for you. You need something with a little more energy, a little more partisan zip, and a little less objectivity. Try Dan Bongino. I think he's more your speed. So, look, we've talked our way through the warrant. My prediction is the motion to dismiss will be denied. Mike says partial grant. Let's keep an eye on what Judge Cannon does. Never a dull moment in Trumpista world.
Well, and I am interested to see what part of the motion to suppress will stick, if any, right? What components of that poisonous tree will be excluded or suppressed from evidence. Anyway, Severe Conservative says, I wonder if non-Connecticut listeners caught that Norm won Bridgeport Superintendent of Schools case with the same judge on Alex Jones' case. I don't know. Doubtful.
Yeah, she got reversed on that. She gave us the quo warranto decision. We got the Bridgeport School Board chief removed as unqualified for office. The appellate court reversed her. She has suspended me. I'm hoping that in an hour and a half, the appellate court reverses her, but I have my doubts. Stay tuned tomorrow. And if you've got any work that you need a former lawyer to do, let me know. I don't want to sell pencils or sell life insurance policies, but I hope to be back at it soon.
We'll get you to. You'll be the first woke insurance brokerage agent in the world.
Something like that. Yeah.
Anyway, we'll be back here tomorrow morning, 8 a.m. Eastern time at LawPod Daily on YouTube, on Rumble, and on X. You can also find our audio-only podcast. Somebody needs to give Norm a damn compliment on the sound quality coming from his side. I mean, good God. You guys were saying hey to the birds last week, and my man is very professional this week.
Yes, that's right. Thank you, Mike. Thank you.
Oh, thank you. Thank you.
Right. Talk to you tomorrow, folks. Ciao.
See you later. Bye.
AMF, yo-yo.
AMF.